Welcome to our Lunch and Learn event entitled How is Section 23 of the Charter of Rights and Freedoms Understood in Quebec? I'm Patrick Donovan, Affiliate Professor, Department of History at Concordia University, and the Research and Operations Manager at QUESCREN. I'll be moderating the event today. I would like to begin by acknowledging that Concordia University recognizes the Gani Nation as the custodian of the land it is located on. Jojake, Montreal was a gathering place for many First Nations, and today still is, and is a home of a diverse population of indigenous and other peoples. We continue to reflect on the many ways to work with indigenous communities, and I know for a fact that Raphaël, our main speaker today, has spent many weeks over the past year at training sessions with indigenous educators in Alberta and in Quebec to explore ways to better integrate these perspectives into our education curricula. This event is made possible through the financial support of the Secrétariat relevance avec les Québécois d'expression anglaise. QUESCREN also receives funding from Canadian Heritage and Concordia University. And please note that this is a space for intellectual exchange and that any views or opinions expressed in this talk do not necessarily represent those of QUESCREN or its funders. It's now my pleasure to introduce today's speakers, two very engaged QUESCREN researcher members, Doctors Raphaël Gani and Anthony DiMascio. Raphaël Gani is an assistant professor of history education at Université Laval, whose projects link educational rights, school curricula, and the concept of legitimacy. His thesis, QUESCREN Research Briefs, and upcoming edited volume with Jérôme Gosselin-Tappe address all these links. Anthony DiMascio is a professor in the School of Education at Bishop's University. He's an educational historian, and his research focuses on the origins and development of mass schooling. He's particularly interested in the intersection of educational history and politics, and how it can contribute to informed public policy. I'd also like to add that Raphaël, Anthony, and I are all working on a one-day colloquium at the ACFAS Congress on the topic of Section 23, so the very topic of this presentation. And that one-day event will take place on May 9th with a keynote address by Thomas Mulcair. This is at ACFAS, so it's worth noting that most of the presentations there will be in French, but there's a third that should be in English as well. So if you're interested in hearing more about this topic, my colleague Anna will share the link to the ACFAS Congress in the chat. So now I turn over the mic to Raphaël.
Hello, everyone. I'll just share my presentation. Okay, is everything's okay? Good. Okay, so welcome everybody. This talk is titled "Who Hear Us When We Speak About Section 23 of the Canadian Charter of Rights," which is related to official language minority rights, commonly known as Anglophone in Quebec, or English-speaking minorities. We're going to present to you a survey that was done with over 1,000 Québécois last week. So is still pretty fresh, fresh out of the box. So the analysis is not super deep, but I think we can learn from the first insight that came out of the survey that was long in preparation, and as Patrick said, is related to a colloquium that we're going to do on ACFAS on Section 23 in Quebec. So to start with the more legal framework and historical framework of Section 93, I will pass the microphone to Anthony, known historian of question of linguistic rights, and just to set the terms, and then after we'll go more directly with the survey finding.
All right, thanks, Raphael. Good afternoon. So like Raphael said, I'm going to give a brief overview of what Section 23 is and why it's important within the context of public schooling in Quebec. And I'll do this mainly through an historical perspective. So from an historical perspective, it's extremely important because we're talking about the relationship between the federal government and the provinces as it pertains to education. One of the enduring myths in educational discourse in Canada is that there is no federal involvement in education, that there's a firm line of demarcation between jurisdictions of power, and that the federal government stays out of education, which the Constitution makes a provincial jurisdiction. This isn't entirely true. Certainly, Canada is a federation of different provincial entities. And when the provinces came together in 1867, they agreed, to the chagrin of some federalists, that education would come under the powers of the provinces. And so, yes, it is the provinces that have the legal power to establish the general administrative structure of the school systems, determine the curricula, establish education laws. They initiate a host of subordinate legislation or regulations, and so on. That much is clear. But historically, the federal government has had a role to play as well. I mean, there's the obvious example as well of Indigenous education in Canada and the role the federal government has played there, but also within provincial matters. It continues to have a role to play in education. When it comes to things like access to schooling and the protection of minority rights in Canada, it has a very important role to play. Historically, we've seen this, the slide is up there, we've seen this through Section 93 of the Constitution, which gives Catholics and Protestants in certain provinces, today that would be Alberta, Saskatchewan, and Ontario, and up until 1997, it was Quebec as well. It gives those provinces religious minority education rights. And if the province aren't holding up to it, Section 93, you can see there, specifies that appeals can be made to the federal government. And they have over the course of Canadian history. Some of the biggest episodes in Canadian educational history have happened at the federal level. If you think back to the Manitoba schools question as an example. So despite the Canadian Constitution placing education under the jurisdiction of the provinces, the federal government has been historically the guardian of Canada's system of public separate schooling, publicly funded separate schooling. The courts have also played their part throughout Canadian history, as a number of challenges and attempts to deem Section 93 invalid have been brought to them. And the courts have held firm since 1867 that Section 93 offers clear, rock-solid protections to Catholic and Protestant minority school boards. In Quebec, this protected Protestant school boards, the de facto English school boards, shielding them from any challenges against their legitimacy or from provincial governments who wish to eliminate them. Section 93 could only be removed through a constitutional amendment, which Quebec finally achieved in 1997, and is not up there on that slide, but the line that was added was essentially that Section 93 does not apply to Quebec. So Quebec did this by forging a public consensus in the 1990s. For their part, English-speaking Quebecers were willing to trade essentially a religiously divided system for a linguistically divided system. This raises a huge historical question of whether the community knew what it was giving up in terms of the rock-solid protection that Section 93 afforded the Protestant school boards, again, the de facto English schools, when it conceded, rights over those schools. But that won't be the point of the talk today. I will be talking about that at the ACFAS colloquium that was mentioned earlier. But back to the point today, what made it easier to forge the consensus in the 1990s was that since 1982, if we can go to the next slide, the Constitution had also granted linguistic minorities educational rights under Section 23 of the Charter of Rights and Freedom. Now, Section 23 essentially says that Canadians have the right to have their children receive primary and secondary school instruction in their own first language. That's Section 23(1)(a), in the language they went to school in themselves, Section 23(1)(b), or in the language that their child's sibling went to or is going to school, Section 23(2). Section 23 has its limits. First of all, it has to be read in conjunction with Section 59 of the Constitution, which explicitly states that Section 23(1)(a) does not apply in Quebec. Very important for Quebecers to understand until the National Assembly of Quebec allows it to, which it has not done to date. Section 23 has other limitations as well. Section 23.3 requires that there be sufficient numbers of children to warrant the provision for public funds for minority language instruction. Now, the charter, when it was drafted, didn't define what constitutes a sufficient minority. They left it up a sufficient number, excuse me. They left it open to an interpretation and case-by-case assessments. There have been many court cases. The most famous is Mahi versus Alberta. And it was in this case that the Supreme Court affirmed that parents exercise a degree of control over minority language education. And it did this by establishing a sliding scale approach. In practice, this means that control over the level of minority language education provided through Section 23 should be proportionate to the number of children requiring it. So, for example, Section 23 can be triggered at a very low number, where a local school would have to offer, say, a minority language program within the local public school at the parent's request. Or as numbers get higher, then more management over the schools themselves is warranted, such as management, full management over facilities. And at the higher end of the scale, even a publicly funded school board managing several minority language schools would be warranted. The case we have in Quebec. Again, the schools in this case all fall under minority language community control, as affirmed by the courts. And as we've seen in recent court rulings over Bill 40 in Quebec, Section 23 may be proving to give some solid protections to linguistic minority education. This makes knowledge of Section 23 extremely important. It's a very powerful legal instrument for minority language speakers. And so to what extent are they aware of it? With that, I'll hand it back to Raphaël, who can speak more to the question of how Section 23 is understood in Quebec today.
Thank you, Anthony. So just a couple of contextual studies and surveys that probe Canadian understanding and knowledge about Section 93 of the Charter. We know from a survey that most Canadian and most Quebec, although a bit less, find that the rights of official language minority are important for the Canadian identity. We also know from another survey that linguistic minority rights, when we put them against all other kinds of issues in Canadian life, such as liberty of expression, are ranking pretty low. So this is not a hot button issue for the majority of people. And there's also a study that shows a double standard. It's kind of dated now, but with the way in which Anglophone majority or English-speaking majority in the rest of Canada, as we call it in Quebec, approve and support the rights of Anglophone in Quebec. However, are less sensitive to the official language minority Francophone in the rest of Canada, whereas the Francophone minorities, including Quebec, is more equal in the way in which it support the official language minority, be it Anglophone or Francophone. So that was from different surveys that were done to inspire the survey that we did with the limitation of previous studies in mind, meaning few questions were previously asked specifically about linguistic minority in Quebec, let alone few questions on the way in which Section 23 is applied in Quebec. And then again, the difference between Quebec English-speaking minorities and Francophone in regard to Section 23, its application in Quebec, especially. So that's what we aim to do here through a research brief that will be published for QUESCREN, where a lot of methodological detail will be obviously exposed. Here is some of them. What's it's important to know is that survey was done 2 weeks ago, so it was long to create it, and we receive it this week. So that is bear in mind when we analyze the data. Survey that was done by Léger Marketing, standard process through their online panel with all the limitation that comes with it, yet still 1,015 people answer, 18 and over. And I specifically ask for an over-representation of quote-unquote Anglophone. I will explain that later. So we have 600 Francophone and 250 Anglophone, 150 Allophone. I will mostly focus on the both Francophone and Anglophone. I'll explain why later. And we have this survey with several questions. 40. I will treat it about 5 questions today. It take about 10 minutes to fill online. So let's get right to it. Because the question we're all waiting for is, do people know Section 23 of the Charter? So as I put it in French, it was back translated to make sure that the translation is correct. Know that people could answer the survey in English if they wanted. So I start with a bigger sample, everyone in the sample, without regard of their affiliation. What you need to understand here is yellow and red are people who are either not sure that they know or they don't know. So most people are not really knowing what we're talking about. They don't hear us when we say Section 23 of the Canadian Charter of Rights. Then again, it's important to understand that within that bigger sample, there's 2 more clear-cut sample that I could, in a week, extract. There's obviously some limitation to that, but that was the one that I could mostly look upon to compare. As Anthony showed, Section 23 grants right to citizens of Canada who have first language learned English or French and English as their first language, and they have also done their primary instruction in English in Canada. So I made a closer cluster of what I call ayant droit or rights holder, and it's in theory. We don't have specific knowledge of if they are, but they meeting these criteria to their answer to 3 different questions that we added in the survey. And Francophone are the citizen of Canada, which have their French as their primary language and have not go to secondary or primary school in English. And I know it's kind of, there could be lots of talk about that, but that's what I've tried to use in order to get some sense of the data. And the allophone category is very complex and nuanced. I prefer not to go there for now. It will be obviously in the research brief, and I'm mindful that to take all the account, all the diversity that's within all these groups too. So, as I say to you, who knows Section 23? Where they're part of it is to understand who knows that section. If we divide the corpus in rights holder, that's mean from English speaking, and Francophone, we see a slight difference. Both group kind of don't know the red. They don't really know it. 46%, 43%, or even a bit more of Anglophone who don't know. And sorry for the language of, I'm just trying to hold that group and name it in some kind of way. But as we see, there's more uncertainty. The yellow, we neither know or not know if we understand that section. More in Francophone side, 40%, and 17% in the green side on the Franco know that section compared to 25. So there's slight difference of people who know. The green is really people who are either mostly certain or absolutely certain that they know section 23. And so we're not speaking to a lot of people when we use the word section 23. Mostly the green people, I would say for now, from what I understand from that question. So part of the reason we did that survey is the legal context in Quebec. Obviously, there's four either ongoing or mostly resolved. We'll see with Bill 40 what's happening. But let's say that we're not going to talk a lot about access to schooling today. I'm more interested, as Anthony said, one of the key jurisprudence in Section 22 is Mae, Arsenault Cameron, and others have more delved into the governance of what does it imply, for instance, to have school for the official language minority in terms of hiring people. Mae say they can hire people. But the Bill 21 in Quebec, there's a litigation over who decide who's to hire in the Anglophone school system. That's one who will go to the Supreme Court. There's the Bill 40, which on the governance, the change to Centre de service scolaire to school board, which as of last week, I haven't read completely the judgment, but it's been won, if I can say, quote unquote, on this appeal court. Let's see if Quebec now studying if they're going to push it further in order to govern to the school board system still. There's the Bill 96 we're going to be focusing today in line with a linguistic law, new charter of language, things such as the way in which English-speaking representatives from school can speak with the government in English or French, for instances. It's still contested right now over the court. And this big question that it's still unresolved in court, whether Section 23 apply or not to university. It's debated right now on Campus Saint-Jean in Alberta. And there's a litigation here. All of those mobilize Section 23, the last one being Concordia in their brief, who mobilized 23 to justify that the right to govern for Anglophone. So let's go ahead. And who knows about what we're talking here? You might be one of the people who understand one of these cases or some of these cases. So let's see, again, generally speaking, all the corpuses. Let's see the general population, 2015, 45% of people are either mostly certain or absolutely certain that there exists an English-speaking minority in Quebec according to the Charter of Rights. That's interesting. I'll let you sim on that. The government of Quebec is actually implicated in judicial contestation in relation to the right of the English-speaking minority. 49% no. And there's a contestation that will go over the Supreme Court due to Quebec government behavior towards the English-speaking minority. 40% no. So who hear us right now? If we look at the population, it looked like about less than 50% understand what we're talking about when we talk about legal terms such as official language minority from English-speaking background. A bit more know the contestation, but still it's mostly less than 50% who knows the current context that predisposed that survey, which is trying to understand what people think about Section 23. Let's dig a bit deeper into one specific area. I don't have limited time today, so I'll dig into this question that I chose. I think it's very telling. It's going to get us a bit far, I hope. English-speaking representative from Anglophone school should only communicate in French with the government of Quebec. That's one of the area that is debated, or it's in the air right now with the Bill 96. And the general population, when asked whether they agree or not. So it's an attitude item. Most of them agree. It's not the majority of the people, but 41.1% agree that only French should be used in communication with the government. And here, it's all the people in my survey, 1,015. Neither agree, neither disagree, 26.1, and disagree, 32.8. So let's dig deeper into that Bill 96 related issues. We see that communicating in French with the government is perceived vastly in different ways if we look at Anglophone right holder, as I call them in theory, and Francophone. 63 in red here on the left mean that most people disagree as a right holder with the need to communicate only in French. And then it goes from 15 neither, and 22 they agree. On the other side, we almost see a little mirror effect, although not in the same proportion. 51% of the Francophone, they are 500, I remind you, whereas Anglophone are 200 in there. So 51% of 501 say that Anglophone representative from school should only communicate with the government in French, whereas 29 neither know or don't know, and 20% disagree. So we see a mirror effect, which might not necessarily be surprising to you, but it's a contention right now in the issues of Bill 96, and it's important to see how people are sensing that. And trying to explain that issue is also a bit nebulous. I've used the collective angst tool, which provided by a study of Michael Wool, social psychologist, which theorized that people have emotional reaction in face of the future of their group, whether they feel threatened, whether they feel their group, and here it's on the collective side, not the personal, but whether they feel their group, like the Francophone society in Quebec, will disappear. That's what it's called, collective angst. It can come from the way in which the group recall its past. In Quebec, we know from studies the narrative of la survivance, for instances, saying there's always been conflicts and assimilation threat in the past for the Francophone group. It's also a characterization of collective angst, a feelings towards an uncertain future. And that's the claim that it helps me use is that angst can then lead group member to adopt protection measure against other groups. And in that case, it could be used to not give rights to the other or even preclude the English-speaking minority from getting rights. So here is a new data that has been shown before. Surveys are now done often on this question. Please see under Franco and ayant droit, you see mostly or absolutely agree with the question, French language is threatened by the English language. So if we ask Francophone and Anglophone, they have completely different answer on that, and that will be my biggest claim today. I don't know how much this is known. I've read a lot about Francophone being threatened. I haven't necessarily read them in comparison. So most Francophone, up to 73.7%, feel that the English language threatened the French language. It's aligned with other survey that now ranks around 75, 73. It's close. So that number is important to consider in the section 23, whereas how it affects people granting rights or not to Anglophone. And the other, the rights holder, 201, what I call them, is 75.6% are mostly or absolutely are not agreeing, disagree with the fact that the French language is threatened by the English language. So, what can we derive from that? Let's scale back to my initial question. Remember, we were talking Bill 96. So, do people feel, Francophone here, upset, do people have an attitude that English-speaking representative from Anglophone school, basically people who are working for the state of Quebec, should only speak in French to the Quebec government? 50% of Francophones say yes. And my claim is that's mostly the same people who are also saying that the English language threatened the French language. So that's the number here, 84.7% of people that who are saying those two things. They're saying basically people who want Anglophone to speak in French to the government are also the same people, mostly the same people who are saying, it's descriptive data, so I cannot go to links, but they are mostly the same people who are also saying that the French language is threatened by the English language. And lower, we see the complete opposite, which is kind of interesting. People who are called right holders are saying we mostly disagree. We are not necessarily agreeing. We don't need necessarily to have English-speaking representative to speak only in French. 62% of the English-speaking group that I've surveyed are saying that, which are also the same people that are saying that the English language does not threaten the French language. So here is, you have even a stronger number, 90% share these two opinions. I cannot claim thus far, I will need further analysis, but this seems to be those people who hear us and hear, and the way they filter the information when they hear about legal challenge brought to Section 23, and sometime when it's operationalized to can representatives speak in French to the government, then it's understood through that lens of, as the survey seems to indicate, we'll need further verification, to the notion of threat to the English language, that the threat that it's doing to the French language. So what can we conclude from that? Our survey, still in analysis. I received it this week, so bear with me. What we can see when we speak about legal and precise language about official language minority in Quebec, according to the Charter, and even Section 23, we speak to less than 50% of the population, either Franco or Anglo, I will argue, based on what we see. We'll need to further verify. We see similarity and difference between what I call right older, like I said, it's in theory, it's self-reported, and Francophone, especially in the role of collective angst, but it's like a reverse. Groups feel it's threatened and seems to then say, we're not going to let this continue, therefore we reinforce the French language. It's just an explanatory model, but it's not the confirmative. I cannot really say that for sure. It seems to emerge from the data. So with the judicial recourse right now, I'm mostly focused on with the time allotted to Bill 96. And we see a fundamental cleavage or a chasm on the way in which the people should communicate to the government, which is a basic notion of citizenship, which is the relation with an individual toward the state, therefore the language he can use or not, and the role of la menace, the threat that I've read about in, for instance, the book in Langue des Voix that was published with Bernard Gagnon and François Rocher writing about it. It's been known that the feeling of threat is present in Quebec. I've tried to link it with the way in which people then might use or not necessarily be, it be coexistent with a vision of the rights to give or the attitude toward the rights of official language minorities. I have plenty of other questions on Bill 21, Bill 40, and school curriculum, the way in which they should be the same, different, the way Anglophone minorities should govern, and the way in which it should govern its system, and the way it should hire or not who they want. In the survey, I didn't have the time to analyze it, or it wouldn't do justice to present them just 2 weeks after they've been sent out to people. But we can see each other at ACFAS on May 9th, and some of those results will also be distilled. There's a research breach coming, and there might be even a little short communique to have the most of the result sooner than later, so we could continue the discussion on the way Section 22 is understood in Quebec. Thank you.
Thank you very much, Raphaël. Anthony, we're now going to move on to the question period. I would like to remind audience members to put all questions in the Q&A box. We will be going with written questions. There are already 2 questions in the box at the moment, and I have a few of my own. So let's start with the first one from Deepak Awasti. The English and French have always spoken from the minority perspective. They'd never seen each other as national groups like Pan-Canadian, and thus have always claimed that one was always a threat to the other. The provinces have taken advantage of this either by inadequately protecting or attacking linguistic and socio-cultural minorities. Should the federal government not be asserting its authority over the provinces to ensure that our national language rights are protected? So I guess the broader question is how, to what extent should the federal government be affirming itself in this case? And this is a question from Deepak Awasti.
Anthony, you want to? I think you spoke about.
Yeah, I can start off, and then I'll hand it back to you. I mean, part of what I think I was getting at earlier is that in many ways the federal government already has asserted itself. It's given minorities a very powerful legal instrument to use, and that's part of what Raphael have spoken about in conversation together. Right? Is how aware are people of the power of that legal instrument and their ability to use it. So to answer your question, without getting into the nuances of it, of what you were saying, should the federal government exert? I think I would argue that it has by way of Section 93, and now the question is how do the people use it? Raphael, I don't know if you want to add to that.
Well, to use it, they have to know it.
Yeah.
And that's what we wanted to see. We're going to continue looking into different question of knowledge. We have more question about right or wrong kind of question that we analyze, such as does the Charter of Rights apply to Quebec, for instances, Canadian Charter of Rights. We'll analyze that further to see if people know about it, but to mobilize it, you have to know it. And so we see that when we spoke right now, it's less than 50% who can follow that conversation. And I think on the role of federalism in the education, I think it might be even less.
A related question. I often hear from people in the community that Francophones outside Quebec are a lot more aware of Section 23 and their Section 23 rights than Anglophones in Quebec. I don't know if you've looked at I know you've done some literature review of past surveys, but do any of these past surveys actually bear this out, or do we not know that information?
Uh, well, by the number of recourses that has been made by Francophone, I could, you know, deduce that they know more on a broader scale of subject for a longer time. I think in Quebec, it has been for a long time access to school, which has been the primary vehicle to understand Section 23. Whereas in 1990 and even before, Francophone were having court cases on governance and in Acadia, for instance, is also further on. So there have been cases related to other aspect of Section 23 and the rest, but no, I haven't found that. The only thing is the double standard, which is a pretty old study, and so it bear a next study that will do a Canadian, pan-Canadian, where to see the difference in knowledge, and it's obviously something that I'm interested in looking for to answer your question, Patrick.
A related question from Andrew Palucci. How would people's knowledge of Section 23 compare to their knowledge of other articles of the Charter, and I guess to the Charter as a whole as well? Um,
Well, that's a good question. We didn't really we know the thing that I've said just before. We're going to look upon whether people can answer the kind of right or wrong question, per contrast to the more self-perceived I know or the it exists in English-speaking minority. But for me, there's an interest. What we know from the literature is there's survey that's been done that show that people find the charter important. Is this type of symbol? And even one survey was showing, I think, in 2020, is that in Quebec, it was one of the places where the Canadian Charter was the most highly rated as a symbol. However, the knowledge of it, from what I've seen of Section 20, and I have not really known, maybe the person knows some indication that they might know other section better. But my intuition was that there's 4 legal recourses right now in Quebec. They all been publicized. It's been the Section 23 has been out. It's one of these section that's been talked about publicly. I haven't seen those types instead of the notwithstanding clause. But I haven't seen other really uh, charter related discussion that would lead me to think that people know more about other section. But for sure, they find it important. The charter is important. Protecting minority is important, but the knowledge of it seems well, still in construction, let's say.
We have another question from Deepak Awasti. In Quebec, the government has long blamed the English as a threat to the French, and in the past 20 years, that has expanded to include allophones, minorities, immigrants, visible minorities, etc. Once again, language and mobility rights are exclusively federal in jurisdiction. Should not the federal government inform the provinces and their populations that they are exceeding their authority by legislating in matters of national concern? Thoughts on this question by Deepak Awasti.
Anthony, I'll let you. The legality of it seems to point
Let's
to
start
you.
with the history of it. Okay, without getting into the premise, it hasn't just been the last 20 years in which allophones are seen as a threat, as you say. This goes way back. We saw it decades earlier, right? At the moment of the Quiet Revolution, with events in Saint Leonard, where there was a huge reaction against the Italian Canadian community, who was pushing for bilingual schooling or the continuance of bilingual schooling, and so yeah, so it hasn't just been the last 20 years. It's always been a case. And what I gather from your questions here regarding federal involvement is I mean it's an interesting question. To what extent can the federal government exert sort of authority over the provinces on these issues. I mean, the reaction to St. Leonard, and there was a march in Ottawa in 68, 69, where Trudeau came out and spoke to the crowd and said, look, what we need is we need strong language in a charter of rights. We need to protect minority rights through legal instruments, through legislation, through laws, and to a good extent, they made good on those, or he made good on those promises with the charter and minority education rights. The question, to what extent can the federal? Well, we're talking about court cases, right? And using those instruments now when the language rights are challenged effectively. Uh, I don't know if that answers your question. I mean, maybe it's not a satisfying answer, and giving you a direct answer. Yes, the federal government should do this, or no, it shouldn't do that. But what I would suggest is that it has provided very powerful legal instruments that protect minority language rights. Now the question is how those instruments get used, and I think that again, that's what we're trying to figure out. And the first step, like Raphaël said, is to know, well, what do people know about these rights, and to what extent do they know about these rights?
A question from Tino Bordenaro of the Advisory Board on English Education. So Section 23 is the fundamental reason why Quebec's Superior Court and Court of Appeal have both ruled that some provisions of Bill 40 violate the rights of the English language minority in Quebec. Do you think that these court decisions will impact the governance and administration of the English school boards beyond those provisions outlined in Bill 96? And furthermore, assuming a similar decision by the Supreme Court, if appealed further, and if the Supreme Court decides to hear the case, do you think that this will further change the governance and administration of the English school boards?
I'm trying to answer the way I've received the judgment from the Court of Appeal last week, which is to go directly on the section on curriculum, because that's my specialty. The Superior Court was at foreground that the English-speaking minority representative school board can advocate for a curriculum and having knowledge, perspective included, but it went further and say that the government has an obligation to take into account these advocacy suggestion in order to not interfere with the preoccupation of the minority. It was Juge Lucier who said it, and I read it, that passage, because it was one of the first judge to actually define in the governance of curriculum. I'm sorry, Tony, I can't really go on the school board level, but the governance of curriculum, which in Quebec is mainly by and for Francophone, it said, no, you have to take into account and not only invite people at the table, but take into account, meaning that you have to show that you have taken into account. So that was a big step. I've studied that very closely in recent year, as you know. And what's interesting is in the Court of Appeal last week, not Judge Lucier, the new one, they've basically granted the win, if I could say. I haven't read the old thing, but on curriculum they retracted, and they retracted from Juge Lucier, from what my initial understanding, and they say on the governance of curriculum, they say, well, Mae and other judges have said that there's a balance to be struck between a minister of education rights to impose and the minority rights to not be interfere in their preoccupation. But it said that balance shouldn't let judges to tell the legislator what to do. So we're going to retract from telling the government of Quebec about the way in which English-speaking representatives should participate and therefore be taken into account in curriculum, which therefore I see this as a backtrack from Lucier, which is very important. I'm still going back and over, but up until in the curriculum, just for the curriculum, I'm sorry, not the school board, but for the curriculum, up until English-speaking representative will hold the pen at the table and write some of that curriculum, it'll be very difficult to have their concern taken into account. And the Bill 40, Court of Appeal, have kind of let the leverage out that Lucier had give the community to be taken into account. So that's my reading just of that for the curriculum.
So, I mean, the way I understand it here is on the one hand, we've been discussing what the law says, but what you brought up in your presentation, Raphaël, is, what people feel. And there's this feeling of threat
Yeah.
From the Francophones that motivates public opinion. And, I guess how do these intersect? In your perspective, how legitimate is this feeling of threat? Can it be used as a legal argument? Has it been used as a legitimate legal argument, or is it? Does it have any legal legitimacy? Does it have any actual legitimacy? I guess that's the million-dollar question, right?
Depending on how you define legitimacy. If you define legitimacy as public support and believe in something that it's true, whether it is true or not, we're not here in the true matter. It's relative, right? Relative deprivation. Yes, we have to take that into account, and that result is with me since I've got it and I reflected on it. And I mean, a government probably knows that. And it has been, if something that has been very efficient in recent year is that discourse on threat, and that the language of the majority population is under threat. Some will go even as the group is under threat and might disappear. And as we see, this is also related. So the people who hear that and accept that as legitimate. So it's not legitimate for all, but the people who accept that as legitimate, 3 out of 4 francophone, let's say, yeah, I agree that it's under threat, are also the same people who say, well, maybe English speakers should only speak French to the government, because probably they feel, and I wouldn't advance, I don't really know, but it seems to put their core identity at threat, and therefore seeing as the language being something that would disappear or be weakened by another, are less inclined to be on the side or be sensitive toward. So to answer shortly, a government who keep priming the threat it's like a dog whistle, which is basically, let's not give those people some more rights, or let's be careful about giving those people. But he's not really saying that, the government. But that's my kind of imagination here. It's just, I'm trying to be like the interpretation is, when you're saying to people that you're under threat, it seems to be also related to other thing, which is Section 23 related. And on the other side, and we see a fundamental cleavage. We see the complete opposite, which the people who I call right holder were basically not believing that. So for those people, it's not legitimate, that discourse. So we have, as Alain G. Gagnon have said, a shock des légitimités, as his book will say, a chasm of legitimacy. We have basically 2 groups in the population, one discourse, French language is under threat, and 2 very different ways to see it, and also 2 different ways to then approach some of the, not necessarily directly rights, but some of the gesture that could be made in order to protect the rights of the minority. So the million-dollar question is, how do you deal with that legitimacy? Well, maybe if we keep pushing, it seems that the threat, and I think here of the book, is La langue française en déclin, which has many people have tried to discuss and try to nuance that discourse, but it seems to percolate very hard, especially in the Franco, and it has the opposite side of polarizing, because there's another group who seems to not believe in that. So then how do you reconcile those two? I don't know.
And I'm going to bring in a third dimension as a final question, because it's 12:55 and this presentation ends in 5 minutes. So a question from Colette Yellow Robe. What are the implications for Indigenous nations in Quebec, or any idea how this has impacted the 11 nations in Quebec. So how does Section 23 relate to Indigenous Quebecers?
Um, I've read a lot of literature on Section 35, which is not directly in the charter, but has been argued by legal scholars such as Gabriel Poliquin and Indigenous scholars such as Nancy Metalik, which are seeing the gain in Section 23 are seen as something that could help Indigenous people argue for their rights to education and governance. For instances, in the case of 2020 British Columbia, which was a gain for Francophone minority in British Columbia to get equivalent access to schooling of equivalent equality, a group of Indigenous people, the Assembly of Manitoba chief, came in the Supreme Court to argue to be very careful about some of the arguments that were made against Francophone, namely that the province of British Columbia was arguing that it was too expensive to respect the right of Francophone. It was too expensive to build enough school to suffice the need of Francophone. And Indigenous group Assembly of Manitoba chief came in and say, wait, be careful about allowing that argument to go forward because we've been served that argument for many, many years, and we don't want a precedent where a government can say it's too expensive to honor a right. So here is where the two intersect, and that's the way I understand is that's some of the argument that can be used against or to uniform to make uniform the language landscape, such as in CEGEP, to be more precise in Quebec, where they have been trying to make CEGEP more francophone. It has directly intersected with Indigenous people being able to access CEGEP in English. And so this is where the Section 23 could be very important just to see how the jurisprudence is acting and not setting precedent, but actually protecting linguistic right, which are obviously very different in English. I don't want to equate those two. They're very different, but from my reading of the situation, some of the Indigenous scholars have been very attentive to the way in which the court are regulating because they see that as a leverage. They see if the court accepts that a group culture has to be preserved to education for Francophone minority and Anglophone minority, then they be hard pressed to say no to Indigenous community, or basically a lot of them making the claim they need access to school to protect their culture and language. So they're very aware to not create a double standard, and so that's my long answer.
Thank
Anthony,
you.
you want to add something to that?
We don't have time.
Oh, we don't have time. Okay, sorry.
Thank you, Raphaël and Anthony. It's 12:59, so I'll be wrapping up. We've gotten a lot of last minute questions, so we'll share them with the two presenters, and of course, you're welcome to communicate with the presenters. And what would be even better is if you came to our ACFAS conference, and then we can continue this discussion with a whole bunch of people who are very interested in the use of Section 23. So thank you all for attending today's event. Thank you to Raphaël and Anthony for joining us. And we look forward to seeing the working paper that will come out of this, that will have a lot more stats and results. The best way to learn about what's coming up in our programming and publications is to sign up for our newsletter, the QR code for which is on the screen. And my colleague will also be sharing the link to the ACFAS event again on May 9th if you're interested in going to that. If you haven't already, you can follow us on Facebook or LinkedIn, the handles for which are also on the screen. And our evaluation survey will appear in your browsers once we exit this meeting. And we ask you please answer it so that we can continue to improve our programming. In closing, we again recognize the financial support of the Secrétariat aux relations avec les Québécois d'expression anglaise and our other funders, Canadian Heritage and Concordia University. Thank you to my colleague Anna Hunt for organizing this lunch and learn and for her technical support today. And I'll see you all next time. Thank you.